9:30 a.m. thereabouts. Ms. Hancock, would you read the roll, please?
Art Howard, Elizabeth Trinkler, Elizabeth Dixon,
Here.
Steve Harb,
Here.
and Chip Hellman.
Here.
Mr. Chairman, you have a quorum.
Thank you, ma'am. Has everybody had a chance to review the minutes? They've been back to Dixon at our last meeting. So, are there any questions? I'm sorry.
Do the agenda first. I'll have a change to the agenda, and then I have a
I'm very
notice.
sorry. Let's review the agenda, and Ms. Hancock, you have some changes?
Before we get into the change I'd like to make to the agenda, I need to read to you the notice given to notice this meeting. And we usually have been putting that. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website. Part of this year's meeting calendar, September the 24th of 2012. The agenda for this meeting has been posted on the Tennessee Collection Service Board's website since May 9th of 2013, and this meeting has been noticed on the Tennessee.gov website since April the The agenda change I'd like to make, I received an email this morning from the young lady who's to appear
Want to change?
That's the only change I have.
I'd entertain a motion.
So moved.
Second?
Second.
And seconded. All in favor?
Aye.
Now we'll do the minutes. Has everybody had an opportunity to review the minutes? Are there any changes? Motion that we adopt or we approve the minutes of
Move
the
they be accepted.
accept
Second.
and seconded. All in favor?
Aye.
Ms. Nelson won't be here. Whitaker.
Legal report. This agenda's going to fly, Mr. Chairman.
Thank you, Mr. Chairman. Wow, that thing really does project. As you'll note, the legal report in front of you has 17 items on it today, and the way we usually do it is to have the board review the report in its entirety, mark down any questions or concerns that you may have, and then once everybody's had a chance to review the report, can address any questions or concerns, and then we can either vote to accept the report as is or as amended with any necessary changes. With that, I'll turn it back over to you, Mr. Chairman.
Thank you. Let's just take a few minutes and we'll read the legal report. Oh, are everyone through reading their legal any questions anyone have? Okay.
Imagine the board has previously determined what is deemed to be a collection effort. And in the case of placing them on the Bureau, in the board's view, is not an effort to collect a debt. Is that
I'm sorry,
placing items on the Bureau?
credit reports?
Yeah, credit reports. Isn't
No, sir. Just placement on credit bureau reports, no. But there are actions that could be taken subsequent to that. For example, that's why the detailed explanation. If somebody called in and these folks said, okay, well, yeah, this is with a collection agency, but we'll try and go ahead and settle it for you. They can't do that, and so that's kind of where we are. And the reason for this recommendation is, for one thing, the file doesn't contain any provable, admissible evidence at a potential formal hearing that they've actually done anything like that. However, in speaking with their attorney, I got the sense that, while his clients, especially the leadership, are good folks and want to try and be nice to people, he actually essentially asked for this letter of warning because he thinks if he takes it to the president of the company and says, look, this is the kind of stuff that can get you in trouble, cost you money, and if you insist on doing it, then you should get a license because the requirements are not that onerous. But if you don't want to go through the licensure requirements, then you need to follow what this says. And so I think this recommended disposition is assisting and being proactive in preventing potential violations down the road. And if they do violate down the road and we see them again for this very thing, they certainly wouldn't be able to say, oh, well, we didn't know anything about that.
disagree at all with your conclusion
Okay.
of what we're doing. I just wanted to understand at what point you've made an attempt to collect a debt in the eyes of the board. Debtor, is that not an attempt to collect a debt?
Well,
Unless the debtor initiated it.
That's kind of a sticky wicket, to use, colloquially. But that's one thing which I've got a brief presentation to the board about some things having to do with the passive debt buyer clarification statement anyway, that will cover some of the difficulties that we've had in demarcating that line, and how recent case law, even though it's federal and not state, may cause the board to have to potentially reconsider the clarifying statement and or to maybe add some clarification, because currently the Tennessee Collection Service Act, in the definition section, at one point it uses the phrase collection activity, but that is not a defined term. And, I can imagine that there would be lots of feedback input from the industry and otherwise, were the board to attempt a statute and or rule change to set forth what that means. Because it's not currently a defined term. It could help in terms of guidance, but at least historically, the board has determined that being a passive debt buyer and not initiating the steps to contact the debtor or trying to collect the debt is, doesn't represent collection activity. I think the distinction that they've drawn is if the debtor calls in after seeing it on a credit report, there's really not a lot that the passive debt buyer can do to stop that, but what they can do is make sure that they are complying with the law during such contacts. And pretty much anything other than, hey, this has been farmed out to ABC Collection Agency, talk to them, or it's currently in litigation, here's our attorney's name, go talk to him. Pretty much anything other than that, they're really running the risk of unlicensed conduct.
I think that's what a passive debt buyer would do, is refer that consumer agency. As an ex-agency owner, I know I wouldn't want my client speaking with one of
And I did get the sense that that their attorney is really on the ball and on top of things and trying to do the right thing and wants to, even though they're in New York and don't have a Tennessee license, they really do want to comply with the law, and because they don't do a lot of business except really in the Northeast, then they may not have even the regional familiarity that a company with a location somewhere closer to Tennessee might.
The risk they run is when somebody from New York moves to Tennessee.
That's true, but that's the risk you take in the business that they have.
Number 5, Chris.
Chairman, can you speak into the microphone?
Yes, I'm sorry. Number 5.
Yes, sir.
Did the agency actually ever send a validation notice? It says that she requested one.
Yes, Mr. Chairman. If you read, I think it's sentence 3. The complainant also requested validation of the debt, and the respondent timely responded to the complainant's request for debt validation.
This is an unlicensed agency?
It is.
Would there not, are they not, is there some reason that you feel like that they shouldn't be, an agent shouldn't be admonished for collecting without a license?
Well, in this particular case, aside from this being their first appearance in front of the board, part of the issue is that the complainant, who's a very nice young lady, I talked to her at some length, she's just happy to be over and done with this and wants it put behind her. So even if myself and Ms. Ryan were inclined to proceed to a formal hearing, you'd have to have the cooperation of the complainant, and we don't have that. Because once she was able to work with her school and get it transferred to another agency for her to deal with that she could get along with better, she's like, it's over, it's done with, I've paid these people, I just don't want to mess with it anymore. But, at least, again, with the letter of warning, they're on notice. And what I could also add language to the letter of warning regarding unlicensed conduct so that it would advise them of two things. Not only, don't try and collect more than you're owed, but, oh, by the way, if you're going to collect in Tennessee, you need a license. And it would also, I would need to amend it to include cease and desist language to the extent that they are engaging in any such conduct. That way, so you got cease and desist and a letter of warning for unlicensed conduct and collecting more money. Sure.
And additionally, should the school be noticed that they can't hire an agency that's not licensed? Because that's a violation of our act too, that they indeed hire an unlicensed.
Okay. I can talk to the school about that. I wasn't aware of the statutory provision that said it's against the law for an original creditor to hire an unlicensed agency.
Maybe I'm using the wrong terminology because I'm not a lawyer, but there is some at least in the past, and I know we have admonished some companies that continue to hire unlicensed collectors.
Even if there's not a specific statutory provision, I do think there's some contact information in the file for a good point of contact at the school. So I'd be happy to make a call and before I close the file and talk to these folks and say, look, this could cause not only whoever you hire for this some problems if they don't have a license, but without giving them any legal advice, tell them, look, there may be other laws and rules that I don't know about that you may be in trouble for. I don't know if that's true or not, but if it makes them think a little longer and harder before trying to work with an unlicensed entity, then it might be worthwhile to just make a phone call.
13. I suppose.
One moment, Mr. Chairman. I
Okay.
need to write some notes from number
Okay.
5 so I know what I've got to do. All right, Mr. Chairman, thank you. Number 13?
I think just in order to correct the minutes, that number 13, first year license 2014, it's probably a typo.
That would be the
We will fix that.
15 is this agency license, are they conducting collection agency business at all?
One moment, Mr. Chairman. Mr. Chairman, after additional review of the file, it looks as if the named respondent in this matter is a passive debt buyer, but who the complaint actually should have been against was the servicer for the debt, who is a licensed agency. And so the recommendation does not change, but what I'll need to do before we close the file is to substitute the name of the servicer / licensed collection agency in place of the debt buyer, because that's appropriate given the facts of the case.
Any other questions? I entertain a motion that we accept the legal report with changes.
So moved.
Is there a second? Second. And seconded, all in favor? Aye. Ms. Hancock, administrative report.
Okay, if you will turn to tab 3, that is our usual report. This year versus last year. The top grid is where we were May the 1st of 2012, showing 96. Going in and out, so just hit it. 29 of which were over the 180-day benchmark. Those that May the 9th of 2013, 40 complaints. Some of those today, 9 of which were on the 9th over.
Excellent. That's the best I've seen it in 10 years, so congratulations, Mr. Whitaker and everybody.
All voted on the legal report.
Yes.
We did.
Who made the motions? I'm sorry.
I made the motion.
Okay, thank you. Sorry.
Other than congratulations.
Absolutely.
It looks better every. Tab 4 is just information I wanted to bring to you that I received. Associations, mail-outs and information that they send out to all the states who are members of NACORA is aggravating. I'm just going to read the first 2 paragraphs. Sorry, the microphone is what's aggravating. I'm going to read the first 2 paragraphs, just go in the record so that people will understand what I'm talking about. But again, if you wanted to discuss this, and I hope you do, and tell me really what it means and how it might affect the collection industry. But this is The American Bankers is what it's titled. And it starts off that the debt collection industry is bracing for significant reform as collectors are scrutinizing their own practices ahead of the first set of examinations by the Consumer Financial Protection Bureau. The agency has begun targeting large non-bank debt collectors, starting with data requests that will eventually lead to physical audits of the operations, including its handling of phone calls, consumer complaints, and relationships with. So apparently there's some testing and auditing coming down the pipe. We're aware of this and could explain what's happening a little better.
I think we're probably all aware of it. I don't know if anybody wants to take a shot, but the federal government passed legislation, I think in 2010, that's going to require the largest collection agencies, collection companies in the country to be audited.
Based on financial?
It's based on volume. There's a formula.
Well, I think it's more based on collection tactics and efforts like that.
It is based on revenue.
It's based on
Based on
the
revenue. Yeah,
Well,
based
that's-
on over
that's
$10
how
million
they choose-
of revenue.
That's how they choose to audit whom they audit. But
They're clear to say that all agencies are subject to their rules, despite the dollar limit. If they receive complaints, they can look into any.
That is correct. And so there is an emerging industry, if you will, that in our business that is in regards to assisting these companies prepare for the federal government audits, if you will.
Testing and licensing, is that going to be required of these companies that meet a certain revenue?
The law that was passed in 2010 has its own set of regulations and guidelines, but compliance with the FDCPA and the other acts that are already on the books is part of what the testing will cover, as well as things like complaint resolution, closed-looped complaint resolution programs within those companies. Again, the government's trying to make sure to do all they can to eliminate abuse, essentially, of consumers. So these large companies, and let's be clear, it's on the aggregated revenue numbers. So a large company can have they can indeed have subsidiary companies and other C corps, but as you aggregate that data, if it hits that threshold, then they're subject to, they will be audited. They will be tested. They will go through this formal process. But as Steve said, they have also made it clear that if they receive complaints, they can go in and look at any company.
So it's like a federal regulatory program. Is that right?
Yes, it is.
And of course, they'll supersede anything that's done.
let's not confuse audit with a financial audit. When they say audit, it means that if you have a $10 million threshold, as right now, they are guaranteeing they will be audited. Anyone. Audit is in their collection tactics and their efforts to collect and what they're doing. It's as far as the collecting from the consumer. It's part of the Consumer Protection Act.
What if they find a violation of a certain company we have licensed? How would that?
I mean, I would view it, I mean, we have lawyers all throughout this room, and they could probably explain it better, but how do we deal with it right now if the Federal Trade Commission takes action on an agency who is licensed as well in our state? Do we get involved, or we just let them do their thing?
The FTC doesn't have penalty authority. Coordinating with the FTC, the CFPB does, and they're splitting the complaints. There'll be penalties and fines. They haven't
Probably-
gone to licensing yet. They haven't moved to that.
That's what I was going to say. I don't think it's really going to interfere in anything we do here. Nothing that I've read would indicate.
Testing is like individuals, but testing of the company?
Testing of their collection tactics. Make, the audit means, well, you calling people and I'm going to break your leg if you don't pay. And
They're going to look at how the employees are trained, make sure that collection employees are complying with the FDCPA. They're going to look at how the companies resolve complaints when a consumer issues a complaint within that company. They're going to look to see that if there's a request for validation of debt, is there a formal process within that company where if someone wants validation, the account's placed on hold? What action is taken at what intervals? It's like an operational assessment, but specifically geared toward the FDCPA and other laws that might be governing that collection activity. Would you agree with that, Steve? I mean, there's a big, thick manual on what they're going to be testing against or what they're going to be looking for when they go in.
Our licensing would be one of their compliance steps. Are you compliant with all licenses you're required to have? That would be what they would look for. If you're not compliant, then they would want you to be compliant. So in a very backhanded sense, they'd be reinforcing state licensing and proper compliance with licensing. They'll listen to phone calls. They'll pick phone calls at random and listen to the collectors.
It is a very big deal. I noticed I got a press release overnight, actually, that it popped this morning, and Ontario Systems Corporation up in Muncie, Indiana, a software vendor, and Columbia Ultimate Cubs, another software vendor, announced late yesterday that they've entered into a strategic partnership for a product that would help agencies with compliance testing for this exact thing right here. I mean, you're seeing some movement out in the marketplace right now where companies are positioning themselves to assist these agencies to go through this process.
the target are debt buyers and the tactics that some debt buyers in the past have used to collect these debts.
I don't see that happening either. There are some carve-outs for healthcare receivables.
Healthcare is not deemed a consumer debt unless it's paid by a credit card. Healthcare debt's paid by a credit card, then that's included in the 10 million threshold. Other than a credit card, it's not consumer debt. That only affects the limitation, the threshold number.
Right. So a pure healthcare receivables company at 10 million would not be subject to this.
Unless they collect everything by credit cards.
Right.
It's interesting that Bill Bartman is involved in this. I'm not sure what he is. It looks like he's formed a company that would do this. He was sued many years ago for some shenanigans that he was doing. He didn't go to jail, but his vice president did. So, but Bill Bartman's quite a guy. He's got a long history. You might want to look him up on Google.
But the CFPB, if you will, I'm still having trouble with the acronym there, or whatever, the initials. But that is an area that you should, of all the things that come across your desk, you probably should keep your eye on things that are in that area because it has some application to what we do here, and it's definitely a big deal in the industry.
I will do that.
Hey, Donna, if they're looking for good compliance officers, though, for the...
Yeah,
He would be an excellent hire.
holy cow.
He'd do a fine job with it.
Security guards, okay.
Will this, Susan, will this be part of our minutes? Will this whole letter be part of our minutes? I haven't read the whole letter. Okay.
Would you want the whole letter to be
Yes,
made
ma'am.
part of the minutes?
Yes, I'd
As an
like to see,
attachment?
or
Yeah,
I'd like
copy and
to,
paste
better
it in
attached.
We can.
Thank you.
And if there are no other comments about that, we can move on to tab. First page you'll see there is a report on your revenue that's been collected through 3/31 of 13. So our fiscal year ends June 30th, so we're 90 days away from the fiscal year end closure. So the right-hand column there, you'll see, is where your revenues have come from. Application fees, license fees for location managers, that's in the top block there. Giving you, showing you what the totals were for fiscal years 9 and 10. For location managers alone, $43,970 has been received through 3/31. Bottom block shows fees that have been received from collection agents, renewals and solicitor cards and so forth, for a total of $259,410 through 3. Total of $303,380 so far.
I have a question. Just quick calculation, it would appear that approximately 15% of your revenue comes from location manager, applications, late fees, and that sort of thing, renewals. Obviously, the change that occurred is going to impact that, right? Because that's no longer going to be a source of revenue. So my question, really two questions. I'm sure people, when somebody makes application right now for a collection, to become a licensed manager or that sort of thing, are you all just sending it back to them and saying that new legislation has made that no longer a requirement?
I have a discussion in your packets that we're going to get into under, talk about that whole bill that
Okay.
did away with the location manager, and we'll talk about the fiscal impact it'll have.
That's great. Okay.
The next page over is your expenditure report through 3/31 of 13. At a total of expenditures so far through 3/31/13 was $164,000. It's broken down there as to the individual. Of course, cost-backs won't be added into that until the end of the fiscal year. You can tell from the revenue report the large amount of renewal fees that we received. This cycle of renewal is every other year. Of course, it's larger than. Any questions on the expenditure or revenue reports? All right.
I have no question.
I'll entertain a motion that we approve the reading of the financial report.
So moved.
All in favor?
Second.
Second. All in favor, aye?
Aye.
And we'll move to tab 6, which is a discussion on Senate Bill 148 regarding the location manager license. Of course, we knew this bill was in process, and we knew that it appeared to be moving right along.
What tab are you on?
6.
6. But we didn't know until a couple of days after that bill was signed by the governor that it became effective the day he signed it. Some bills effective January the 1st or July the 1st. This one happened to be effective April 23rd, the day of the governor's signature. So we kind of had to scramble to get the word out that that license is no more. And we got that the license is no longer in existence. Calling, we let them know that if we received their money for application or renewal prior to 4/23, we are not refunding. Work has been done, was been done in good faith, thinking that license. Monies we received after 4/23, we are refunding. As far as the fiscal impact that we talked about earlier, the fiscal note that was attached to the bill before it was started through committees was that there would be a non-significant impact. They estimated a decrease in revenues of approximately $30,600, but there would also be a savings of there would be a savings of that same amount, so that made the
Irritating, isn't it?
You know what, if you and Susan switch seats.
yeah.
Or you could move over
That-
to
Directly
it
into
won't
the
come over any further.
or you could go over to the other table.
Well, I'm about through anyway. One sometimes picks up better. There we go. Anyway, as far as the savings is concerned, there will be less duties in my office. Boys in my office could be his part. Given to another board that we work with where his duties would decrease. Also, we may see that part of your board meetings consisted of reviewing those locations. Talked about that this morning as what kind of impact that would have on his legal report in resolving these complaints.
Sorry for the microphone issues, folks. Kind of where we were looking at this is one of the other programs I have is the accountancy board, as Mr. Harb knows. And the accountancy board meets quarterly, and that's, every 90 days, give or take. And I've found that is a little bit pushing it in terms of being able to get my cases handled on the legal report the way I would like, the vast majority in 180 days, because essentially if I miss one board meeting with the wrong timing, whichever cases needed to go to that meeting for whatever reason but couldn't, aren't going to make it. And that hurts my numbers, and then I get to have fun conversations about why my numbers are suffering. However, if it's this board's desire to meet less often, a potential compromise might be to meet somewhere in the middle of those numbers, what you do currently, which is every other month, i.e. every 60 days versus 90 days. Well, if you wanted to spread it out a little and split the difference and maybe meet 5 times a year, every 75 days approximately, that would save the time and money of that one board meeting, and but it would still probably allow me to do what I need to do on the legal report to keep the numbers where they need to be, and that's kind of whatever the board wants to do. I can make it work either way. So.
I think the consumer, and I don't. Is there a way that we can do it on the telephone or on email, just the legal report?
I would have to look into that a little more closely. I think I'm confident enough to say that trying to do that on a consistent basis would probably run into some resistance at the department level and if not the division level as well, just because, electronic meetings, phone meetings, what have you, those are ideal for emergency things or interim things that need to be taken care of in between regular board business. But if I understand the department and the division's thinking, I don't want to speak 100% for them, but it seems like they are fond of the idea of having the meetings like this so that the public can show up. They can actually see the board do its business in person and have the opportunity to observe and ask questions. And I think that's also the spirit of the open meetings law as well. So all that to say, on an interim basis from time to time, emergency matters, doing it by phone is probably fine, but making it a regular practice, I'm not sure how that would go and if it would be approved.
Your legal report somewhere on the web or somewhere that, is it public record? Can anybody look at your legal report?
After the meetings are done and the final version of the report is submitted, the same anonymous copy that you see, I believe it's included in the minutes, is it not?
It is.
So anybody who wants to see that can go to the meeting minutes of past boards and see what's there.
I'd suggest we leave it as is for now, but we try to measure in some way how that would affect your numbers. I mean, the quarterly meetings, but I don't think it's time to act on that necessarily, but just be mindful of it.
Mr. Chairman, one more thing that Ms. Hancock mentioned is that for the September meeting this year, there may be some issues with hotel accommodations due to like CMAs or some major special event. And if that's the case, the board may want to consider moving at least the September meeting back a couple weeks, maybe like September the 25th, if there's nothing major going on that week. And then if the board thinks that means that 6 weeks is not enough time before the November meeting, which is on November the 13th, could possibly move that back to November the 20th without unduly having issues for Thanksgiving, unless somebody has some.
That was the reason we delayed the opening of the meeting, because a couple of us have had serious problems getting accommodations, and we.
Okay,
While that's not carved in stone, it is hard as
I'll get out.
heck.
That's fine. That was something that was mentioned to me before the meeting, so I figured I'd bring it up anyway.
Was it the difficulty because the rooms were booked because of maybe CMAs, or was it the fact that you couldn't get a stay? I talked to Susan because I knew you were having that problem before the meeting, and we're going to try to come offer regular state rates.
We're okay through
Stay
November.
at the airport.
We're okay through November.
Yeah.
I think part of the record is that Steve and Elizabeth have a room.
Oh, God.
A room. Let's don't go there.
It should not be on the record.
More questions or discussion on Senate Bill 148?
Oh, ma'am, thank you.
Going to move to tab 7, which Mr. Harb had asked at our last meeting to bring application in for review, so that if you saw anything that needs to be changed, we could do that, or get it in the works at least. The only reference to a location manager is on page 6. Got that one line that asks what the location manager's name and license number is. Other changes will be up to you.
Will this be a part of or can you make this an attachment to our minutes, Susan? I'd like to have a little bit more time to look it over. I don't know if you want to try to do it at this meeting.
It's not prepared by an outside CPA.
Proposed budget report, but the financial statement has to be prepared. Number 3.
Licensed public accountants, they're all CPAs. Public accounting.
Uses that for that term, PA.
At least in the past, the 6-month projections that I've seen are just made-up numbers. There's not, anybody could put anything they wanted to in there. There's no way that we as a board could say, oh, this company's going to financially.
This week I had a call from an applicant who is a huge company. Several states asked me how to project and to do in Tennessee, and of course I received that, but what measure do you go by to determine whether that's...
When this law was written and this application was made, it was in the 70s, and things were just different then. We were just a different country. Election agencies was my aunt election agency in the basement of their house, and that's kind of was loosely done. And now how
Cards.
used cards,
Index cards.
Yeah,
It was on index cards.
I remember well.
Agency renews, we just ask for them to provide.
It's the balance sheet in the format that we have it in our renewal. And are we required? It seems that they're required to use that format. That they really can't submit a compiled financial by a CPA firm. And we also have a requirement that a CPA sign or PA sign off on. We've changed that requirement.
They're not being required to sign off on it. They are required to provide on the back of that form the name of their CPA and the CPA's license number, but they're not required to sign it or prepare it.
Well, the CPA gets, the agency gets to use the CPA's name, but the CPA doesn't have to affirm it or get.
We had a meeting
Yeah.
when I first came on board with the assistant commissioner and the there are some accountancy rules that forbid the accountant from signing that form for some reason.
Prepared form. And you can't be constrained to use a pre-prepared form and sign or attest to a pre-prepared form.
So the manager, the CEO, the president, whoever can take the financial information that the CPA prepares, transfer them to that
Not having the form in front of me, and I seem to recall that it appeared to require a signature. Now, I could be very wrong, and maybe the way it's worded.
Susan has asked staff to bring a copy down for each. Anything you see, though, on this particular initial application not clear?
I'll have to look at it more closely, but solicitors' cards, are they still relevant?
Yes. Yes.
Well, it may be relevant to your revenue. I'm questioning whether it's relevant
In the industry.
in the industry.
How
That's,
many times have we actually had a solicitor come before the board for any kind of violation? What are the requirements of solicitors? These are not collectors. The solicitor card is for someone who calls on clients, it's not a collector card, I assume.
and
Salesperson.
I can't remember.
Yeah.
I remember ordering cards,
Yeah.
but I can never remember one of our salespeople ever carrying the card
Or
or.
getting it back when the salesperson leaves.
Yeah, exactly. I mean, I'm not sure that that's not a pretty dated way, and if it's just about revenue, that's not a good reason to keep it, I wouldn't think.
Do we have the definition of the solicitor somewhere handy?
Statutes, it says that 6220-111, no person may act as a solicitor for any collection service unless such person possesses a valid solicitor's identification card issued by the board to such collection service.
A real odd way of reading that might mean that every collector has to have a card, because soliciting for collection services, is there any further definition and regulations?
Goes
Talk
on to
about a
say,
revenue source, that scares me to death.
identification card shall be obtainable by written application of the collection service licensee accompanied by an annual fee as set by the board. Such card shall be the property of and in the name of the collection service licensee, who may transfer them from one of such collection service licensee solicitors to another. The collection service licensee shall be responsible for the proper training and conduct of each solicitor acting in such collection service licensee's behalf.
I've always assumed a solicitor, for purposes of that law, was someone who was selling collection services. But in hearing it cold like that, it may be they were talking about collectors.
Definition of a solicitor means any individual who is employed by or under contract with a collection service to solicit a collection service forms or systems on its behalf.
That one more time, please.
Solicitor means any individual who is employed by or under contract with a collection service to solicit accounts or sell collection service forms or systems on its behalf.
Word "or," to solicit accounts. Now, does that mean to obtain them to be collected on, or soliciting accounts for collection?
Now, well, what's an account? Is that defined somewhere?
Yeah. Scary business here. I'm sorry I waded into it.
Sorry, I brought it up.
Oh, but I've wondered about that, the whole card thing.
Well, what we tell applicants is, it's the people you have on the phone calling.
That's the common understanding I've had since I've applied for a license 20-something years. Reading that definition,
When it says accounts, we don't want to leave an agency up for a lawsuit, because when we refer to the word accounts, it could mean somebody's debt or something.
Yeah.
Accounts also.
debtor accounts are accounts.
I think that probably we could have more discussion on it, and we can have it more today if you want to. There's a couple of things that I'd like to talk about, but I want to make sure and get my thoughts in a row before I bring them up to the board. Is there anything specific that you think you want to address right now, Steve?
Mostly what I was looking for was what we were just handed, but the question of the 6-month projection is without guideline, and how does it provide us value? So what I was hoping is that we would make our application provide more meaningful information as opposed to busy work in some cases, because that forecast is not quantified.
On page 6, for instance, we asked them to give us 6 clients that they're working for, and they shouldn't have any clients.
Yeah, love that.
It's a brand new agency.
I thought exactly.
I was deeply troubled by that one, because if you admit you have clients that you're working for,
Maybe, but if they were to say, put some sort of disclaimer on there, pending license, or we have contracts in place that don't take effect until our license is valid.
seen the sophistication of some of the agencies that apply. I know you have.
Majority of them are in operation in other states and already have clients.
They don't have to be. They could be just a brand-new startup, and it could be in somebody's basement. We don't want to qualify them just because they're a huge company. I think asking the question, perhaps, if you are currently in business, list the 6 clients that
Yeah, because my question would be on that. If I put none on there, do I get, I mean, the implication kind of is that I'm going to be, my application's going to be rejected because I couldn't list 6 clients. Well, I don't have any because I'm trying to follow the law as a new agency.
They put none, I don't believe it has an impact on the processing that application.
That's good.
We wouldn't send that back and say, no, you've got to give us the names of some clients or potential clients. We don't.
Okay.
Well, I think that's what I might be thinking in my mind. If we're going to change anything, and it looks like that we might be, it may be if you are current. We may change the question to if you are currently in the collection business, list 6 clients. Or something for the poor applicant that's out there trying to get into the collection business. He's never been in it before, and he can be in it. License, then he should not have to be able to wonder whether or not he can't be an agency because he doesn't have any clients.
I also think in terms of Tennessee domiciled agencies applying for it, the board does properly, more broadly, go from anyone in all the states to collect in Tennessee, but a Tennessee agency trying to answer these questions and get started, we might add to that, if you're not domiciled in Tennessee, name 6 clients. But if you're in Tennessee and you name 6 clients and you're applying for a license, it's kind of like, wow. Located agency.
Well, like I said, if they put none, we don't reject it.
What we're trying to say is they may not know that they can put none. They may feel like since the question is formed the way it is, that they must answer that question in some sort of an affirmative.
There is another possible thing we might provide as guidance, would be instructions.
Well, is there a reason we asked that question to begin?
Wasn't, no.
So we know it's at least 11 years old. So would it, a reasonable suggestion be that at some point this application become part of our agenda? That I realize it's on here now, but to give us all a chance to review it, and then maybe it's time for either a subset of this group, a work group, get together and try to work on it, or as a board we just allocate some time with a little advanced preparation and we come in and we update this application.
Yeah, that's why I asked Susan if she would include it as an attachment to the minutes. So I'll do that and bring it back to a meeting. Then we're in the process of making some changes.
Not make it a part of the minutes, but also send it to you along with the
That's fine.
or the minutes once you do the construction on
Okay.
it, reconstruction.
I just don't have a copy of it. I guess I can go to the website and print it off. And also the balance sheet. My accountant for 25 years screamed and hollered about this thing. No, ma'am. I held it, I had to hold a gun to his head to get him to, I thought he had to sign it, but he doesn't.
On the other form, the PA or CPA signing it, yeah. This actually has been changed from in the last 5 or 6 years, I would think. The signature part.
Maybe changed right before I came on board, which is
Yeah,
about
'cause
5 years
it
ago.
used to have a signature line, not just the name of the CPA or license. It used to have a signature line.
Yes, we changed that. The accountancy board came in here and had met with us and told us you can't hack.
Well, I just know, again, this whole, even at renewal time, is complicating. I mean, why are we asking for the CPA or the the CPA if we're not going to require them to attest to the numbers?
Precisely.
At one time, they did have to sign this.
I understand.
I've
but
got forms that I provided.
The
where
statute
I
says
had them
it's got to
sign
be
it.
prepared by them, doesn't it? Doesn't the statute say that you have to have a PA or a...
But here we are again.
It does for the initial financial report, but for renewals, it just
tested to, or not even that.
Says prepare the balance sheet, prepare.
Again, this, to the least sophisticated collection agency manager, this is pretty confusing. The CPA's name, license number, and everything's on there, but they don't.
Yeah, and the way it follows the signature line, if it were in another place, but it appears that it's a part of the attestation just on the face. When you look at applicant's affidavit, and I certify, true and correct to the best of my knowledge, and my public accountant's information provided below, it's a real backhanded inclusion. As a CPA, it just, least sophisticated person would look at that and say the CPA took part in it.
application for renewal of a collection service license shall be submitted to the board prior to the expiration date and shall be accompanied by the fee, the bond, a current balance sheet prepared by a licensed public accountant or certified.
What section is that, Donna?
2112B3.
And then we're yeah, bingo, we're backhandedly bringing the CPA into it. The other problem, Donna, years ago, I may have talked with you or another person on the board, I was astounded by the fact, it probably was me, I apologize in advance, yes. I'm astounded by the fact that we could not attach a CPA's in the form of a CPA's, but we actually had to transpose it onto this form. And my question is, why does it have to be on this form?
It doesn't. I mean, we would accept a balance sheet.
No,
Yeah, we do.
I'm rejected. This was before I was on the board.
By this office?
Yes, ma'am.
Well, that was before my time, but if you sent a form that looked similar, that had the escrow information, I mean, the other information we asked for,
I was told specifically in one instance that you had to do the balance sheet on the actual form, and you could not submit an attachment prepared by a CPA.
I think it has been our policy, if nothing else, to accept only the form.
That's one reason I asked to have it brought up, is I'd like for us to perhaps loosen up and have the CPA or a PA compiled with a compilation report at a minimum, submit it, because, you see, we're getting an affidavit from the applicant, which, goodness gracious, most applicants couldn't fill out a balance sheet if it hit them in the head, and allow us to, or require that we get a CPA prepared or an outside prepared form with some kind of compliance reporting or some kind of certification. If we need to know certain items like the cash in bank and trust account, we should have those things be itemized out and listed separately.
Yeah, I think we can, I think
We can have them fill that stuff out, because we do need to know the trust account. But the CPA prepared compilation doesn't necessarily, would not break it out that way.
Please bear in mind, when you start making changes, we do not have a CPA or PA on staff in my office. What we do is look at specific requirements on that balance sheet, CPA name, website, if it's another state, to make sure they're licensed in that state. They say information, assets, and liabilities. If you start sending us something that's going to have to be reviewed beyond that, then it's going to slow down the process and require us to start looking at hiring CPA or PA or sending to office again for review.
I think what Steve's saying is actually can make it easier for you.
Actually, if I may, the fact that we don't have CPAs on our board, if I were going to personally look for Reliance, and someone who's not a CPA was going to look this over and be comfortable by it, the only thing I have is the fact that somebody attested to its validity, and it's not valid. But if I received a financial statement with a compilation report attached by a CPA firm, I know other eyes have done it in the proper format in the form. Now, since it's a compilation, I can only rely on the information that was provided by management of the CPA. But that's still a standard higher than what we're having here, because it's provided by the client or the agency, by their own internal people, and we don't know who their internal people are. Having it come in on an outside form with a compilation report at a minimum gives us a better standard of satisfaction. If we read the compilation report, we don't have to have a CPA on staff. We know it's been done by one. But looking at this, all we know is somebody scribbled some numbers in it and said, yeah, they're right.
Do audits on each firm whether the numbers they put on that form are right or not.
Don't know
We
that
can't
now.
go outside the state.
We don't
to do
know that now.
audits.
That's not a
No.
requirement that's not a requirement. But if I recall, you just read the requirement that this form has to be prepared by PA or CPA. And on the
We can, as the accountancy board has
form, and would you mind reading all part again about what this form has to do? I'm just trying to understand. It's always confounded me, Donna.
a current balance sheet prepared by a licensed public accountant or certified public.
Then it would seem that on the face, the new requirement that's here is not consistent with what you just read.
This form is not prepared by an accountant. This form is prepared by a manager that attests to its validity.
Given the manager a prepared statement, the manager is just transferring the numbers over on that.
We hope so.
Well, we don't know that. Like I said, without doing audits and
See, the CPA's not signing this.
they can't sign it.
I know.
So,
We're going in a circle.
well, what do you want? What would you suggest?
Suggest that the information that we need to know, such as the trust accounts and the trust account numbers and the different bank accounts, we need to know that information, and we should have the manager attest to that information signing this form.
The manager does sign that.
Yes, ma'am. But the balance sheet, we don't know from this form that a CPA prepared it. An in-house bookkeeper can fill out this form, and then they can write the CPA's name that they use for their personal tax returns, because the way this is written, and we don't know that a CPA did or didn't prepare it, or the level of standard. But we do know a CPA prepared it if they attach a compilation report.
Yeah, we can still have our form here, but it needs to be accompanied by a statement that would balance with this information.
The problem that we had with that form is that your statute requires a balance sheet. Probably need a statutory change, but it says that the balance sheet has to be prepared by, and the accountants have said we can't do that because it doesn't meet GAAP standards in their profession, so the way it's written contradicts with what they're allowed to do.
Can I ask a question? Does it have to be on our form? Does our law say that it has to be on this form? Or does it say we have to get a balance sheet prepared by a CPA?
It says balance sheet prepared by a CPA. We have been requiring that form for the simple fact that verifies that information.
But that's something we did
Yeah.
ourselves.
Yeah, that tells you that the company is solvent or insolvent. Right.
That makes, now I understand better. What you just said explains to me why you want it on this form and in this format. That makes a lot of sense. But
It still doesn't scratch the itch of the law,
well,
which requires
yeah.
oversight by.
Because if we had a financial statement or something different and they all look different, since we're not CPAs and we're looking at that, sometimes the terminology is different. And we're like, okay, where's your trust account? That was my trust account, but they named it something different.
Well, perhaps we could not put this in the form of a balance sheet, but say, here's the information we want you to provide us, and attach the compiled financial from your CPA. Require them to extract it in the format we want it, and then have them attach that. Now we've really put them in a box, because they're getting something their CPA prepared. They've knowingly got to put it on this form in the format we want it in. We have what the CPA prepared, and we have that form. If we ever have a question, it really has to match, and we've gotten what we want. Now that I understand why you're having it on the form, it makes perfectly good sense, and we should still require it on the form. But we're missing the requirement that you read in the law that says the CPA has to provide it.
I think what happens with Donna's office is they're not qualified to say, well, the information that the manager has attested to is indeed the information that the accountant prepared. The account, and we've seen some real convoluted financial statements come in here from huge companies that's got all these sub-S corps and what have yous all over everywhere. And for us to try to look at it, and I'm not an accountant, for me to try to look at it and say this company is solvent is impossible for me.
Let's break it into the issues that we have. Okay, we have a need to have information in a format that we can test for solvency the way we look at it. And we want the manager to pull that information from accounting prepared financials and put it in a format we want, and we'll use that. And we're asking him to sign that he's done that. The piece that we're missing is what the law says is that we have to have a balance sheet prepared by a CPA. Now, in the very real world, we don't meet that standard by only requiring this form. If we said we want a form, we want this information that we need, and you extrapolate it from your CPA prepared report, and you have to give us the CPA prepared report with a compilation attached. When a CPA prepares a report and puts a compilation letter, a review letter, or some other kind of report letter on it, they are saying they touched it, smelled it, and looked at it based on the level of confidence the report describes. Right now, we don't know that. We can't know that. All we know is what we got from them, and they've given us the name of their CPA. It could be their cousin. It doesn't imply that the CPA prepared it.
Do you hire a CPA when you send in your renewal?
I have a CPA that does prepare my tax returns. But one interesting point in the law is that since I'm a CPA, it doesn't say a CPA in public practice. It says a CPA.
So you do your
So I do my own, but I do put the information of my outside CPA. If you look on my form, my outside CPA's information's on there, the person who actually does my tax work, because I don't have them prepare financials. Now, we happen to have an audit, so that's a whole different thing in one of the companies that I work with.
If we change this to the way you're suggesting, you would have to,
It would put a burden on me, yes. Personally, it would put a burden on me in one of my companies.
that's what I hear from the companies, in order to hire a CPA to do a full financial report or audit.
No, a compilation
cost
is the
thousands of
lowest
dollars.
level. A compilation is the lowest level requirement, and as a board member, we need to know that we have licensees who are complying with the law and have quality information.
But unfortunately, the law says the balance sheet's prepared by a CPA or a PA. We can't change that, can we?
Well, it's gone along for more than 5 years the way it is now, with them just giving us. Howard, when we've discussed this before in the Assistant Commissioner's office years ago, our attention that the accountants couldn't sign this form because of.
Right.
I thought you were here when this discussion was, so why form ever adopted at that time?
Because we need a form. The form in itself is fine. I think what we're saying is, or what I get, what that Steve is saying is that the statute says a balance sheet prepared by a CPA. And this balance sheet is not prepared by a CPA. It's prepared by the manager.
As a balance sheet prepared by a CPA, and they're simply putting that, which is what we've been accepting all this time. Whether he left off a zero or put a decimal in the wrong place, right numbers, would require audits. It would require us investigating every company to see that right numbers that he's given them. So never regulate that. How would that be?
In the CPA's compilation letter that he says, I don't guarantee anything that's on this report. I don't believe it to be true. All I'm doing is telling you what the manager tells me. It's not a magical report. Huge companies like big collection agencies have CPAs prepare their financials on a regular basis. I think, and we may be backing up a little bit on what we've been approving in the past, of just agreeing that whatever the manager puts on this report, as long as he had a CPA working for his company, then that was all that was mattered. That's all that mattered. But the CPA actually does not prepare this financial statement. And when I was in business, every year I'd take it to him and say, you used to have to sign it. And he'd say, I can't sign that. I won't sign that. I'd have to threaten him with everything in order to get him to sign it. And it was very difficult. And that's what we changed in the commissioner's office that time.
And you put the numbers on there and gave us his name and number.
I think the form in itself is okay, particularly for your office when you're doing your spreadsheets to see if the agency is solvent. I think what Steve is saying and what we may consider here is, do we need to have an attached compilation report prepared by a CPA?
I'm asking Steve now because he's raised this as a question. Would it be appropriate under the applicant's affidavit to change the wording of the affidavit where I certify the attached financial information to be true and correct to the best of my knowledge, and go on and sort of explain that out a little bit? You know, my public accountant has prepared a balance sheet from which I transferred those numbers to the state approved form, And then have the manager and owner sign it?
Well, that'd be great. You just still haven't complied with the law. The law
Well-
says we're supposed to receive a financial
No, it
statement
didn't.
prepared by an accountant.
Well,
It's a-
Balance sheet prepared by a public account.
well, then we got to have it.
That doesn't say what we have to do with it, just says we got to get one. Ms. Hancock, the reason is that it raises the standard of play.
Yeah.
Yes, it's going to cost the agencies more. With the CFPB out there and every agency subject to them and all the regulations, it just simply raises the standard of play to have an agency. Agencies will have, or many small businesses will have, an internal bookkeeper who actually will prepare their financials. They don't really have financial statements prepared at a CPA firm. They actually go to the CPA firm with their internally prepared financials, and the tax returns are prepared from that, and banks accept tax returns as financials from small businesses. And so all I'm saying is if the law requires us to have a CPA form provided, doesn't tell us what we have to do with it. And so it also raises the standard of play for the small firm. And the last thing I want to do is put more burdens on the small firm. Heavens knows they have enough right now. But
we're
I have
dealing
trouble with this side of it because
we're dealing with, these agencies are dealing with consumers' money, and they don't have a CPA prepare a form and give them a letter to the fact that they did prepare it, then we're not in compliance with the law. Two, we don't know that they are solvent. They can put anything they want to down here and make up a CPA's name. Or they could go to the phone book and get a CPA out of there and put that down there.
All of your numbers, you still have the things you need without needing to be
Have
an
it-
accountant yourself.
have it transposed to this. I would honestly take issue with the way it's broken out, because typically you might want to make the form a little longer and have the P&L on one page and the balance sheet on another. The assets and liabilities on one page. That's me. I think I hit it with the paper. I'm sorry. Wow. It's the first time the microphone worked. Just for format. So I'm not suggesting any way that we do away with this form. I'm only suggesting that having the CPA's name under the attestation has an implication that's not real. And if we want it to be real, then we just have them slap the old CPA compilation report on there. All it does, as Bart just told us, is it acts as a filter. Instead of having their internal bookkeeper just prepare the information, they have to take it to a firm and have it put on a compilation form. That's a filter that is a level of protection that I think the law is looking for. Just fine. If this is the information you want, this form's great.
Addition, the attachment that you want.
No. It's prepared by the CPA, and it is, all you do with it is you look at it and go, oh, here's a compilation report, and here's the P&L and the balance sheet, and you'll get a P&L with it. Here's a P&L and balance sheet. It may be a compilation report. Larger companies will have audits. They'll submit their audit.
Review.
All they have to do is submit a financial statement prepared by a CPA or PA, although there's no PAs. All they have to do.
But the law says it. We're not making this up. It's
The law says a balance sheet. It doesn't say a full compilation report and a financial statement.
Oh, okay. In order for a CPA, let me back up and explain. For a CPA to give a company a balance sheet, they have to report on it. They have to give a report because that's their work product. Their work product is not the statement itself. Their work product is their report. They are reporting on information, and they make all outside people aware of the level of information and their involvement. That's what the report does.
Besides the balance sheet, because that's required by statute, what other what are we asking for? What do you want me to ask for?
If we had instructions, you would say a financial statement prepared by a CPA or an outside CPA or PA. It may be a compilation, review, or any form that they prepare it in, and it's okay if it has additional attachments such as a P&L and balance sheet. It's not required. They can be there. It's fine. It'll have to have, at a minimum, a balance sheet and a report from the CPA saying they prepared it at some level of attestation. Cheating, I know that. Yeah.
Well, it seems to me that there are 3, maybe 4 letters that a CPA does. Compilation is the least, the audited report, and a review. And those words, that sentence in that letter from the CPA is pretty much chiseled in stone, I say.
There are some other reports that are now out there that you can do where if you just want a balance sheet, we don't want to put them to the trouble of just having to have a special report. It's whatever the CPA happened to prepare for them, P&L balance sheet, with footnotes, without footnotes. We don't care if it has footnotes or not. All we're looking for is something that shows that the CPA prepared the balance sheet. The only way we get that is with some type of report attached to the balance sheet. They may have additional information. We don't care. And then we'll keep our form. That's all we need.
Most likely, you're going to get the financial statement was prepared in December. Not going to reflect the current trust account information. Statement that was prepared by CPA and PA at the end of the last fiscal.
Has the statement date. So we're looking for it as of, it also doesn't have to be a year-end statement. You can have interim compilations.
About the cost. I can't afford another $1,000 or $2,000 to have my accountant do a financial statement.
Well, then we're in a box.
Well, let me interject a point here. Let's say that we're in a situation that Donna brought up, and the most recent statement they had done was 12/31/12. That is the most recent one they had, then they could send a letter, the person who's got to provide this stuff as part of the application could send a letter along with it, and, with a statement to the effect that there have been no material changes in the financial statement most recently provided to the board, swear it, notarize it, call it a day. I mean, if it's changed substantially, like, the difference in their trust account is thousands and thousands of dollars different one way or the other, then, they should probably let us know that. But
Here's what some other states did. One of the agencies I work with, a lot of states, New Mexico is not your friend. They require a March 31 financial, a compiled financial, to be attached to theirs, and it has to be done within 60 days of March 31. If your financial statement is more than 60 days from the date you file your renewal application, then they don't accept it. And it has to be a compiled financial. Now, the other piece, and I'm just going to pile on here for a minute. Please, Donna, don't be upset with me. The other piece is that we're talking about, it says PAs or CPAs. It does not distinguish between CPAs in industry and CPAs in public practice. A CPA in industry can sign a report with a disclaimer and doesn't do the same report. The CPA in industry signs something that says, I hereby certify that I prepared this in my position as CFO of this company and not as an independent CPA. our requirement doesn't mean, or doesn't say, it has to be an independent firm. It doesn't require independence. It requires a CPA prepared. So we also have that layer of complexity that, hey, while we're throwing bombs, let's lay that one in there too. That makes sense to everybody.
I had this discussion back when you first applied, and we talked about whether you could do your own because you were in house with your.
Yes. As we
I didn't
should.
specifically say that. And so, again, back to, if it ain't broke, what are we trying to fix? What is the,
Well, I think maybe we are trying to fix, because the statute specifically says a balance sheet prepared by an accountant. And this balance sheet, that whatever they're sending it, licensed accountant, whatever they're sending it, when they send this in, is not prepared by. But it doesn't say that it has to be, that this report doesn't have to be the same date as the financial statement. So they could send a CPA prepared financial statement with this report, and the CPA financial statement could be years ago, and perhaps a statement that, like Chris said, that there's been no significant changes, and that our accounts are. So not to put any special burden upon the collection agency, go ahead and keep on using this form, but show us a financial statement from your CPA. It may be a year old, your most recent. Yeah.
I respectfully. Dated December 31, and we get it's prepared as of the end of March. You've got looking for is to be in trust. And to be in trust, we want to know that the CPA prepared financial showed it in trust. Dates of the statements would have to be in line.
Well, the reason I said that is because I'm trying to figure out a way that we can comply with the law, with the verbiage in the law, and at the same time not overburden our agencies by saying if their license expires in November, now I've got to go out and I've got to pay an account.
Rule, or do we have a guideline that says within what time period from filing the application your financial statement has to be as of what date?
broad, a financial statement, a balance sheet prepared by a CPA or PA. That's.
Without any date specification, and we don't have, if your license is up in November and you're filing, you've got till December, I guess, to file it if your license is up in November or some period of time to file it after specifics.
What do you use? A current, or do you go back to?
Like the most recent financial prepared, typically it's going to be a quarter end. But our license renewals, do they come at odd months or do they all fall? They come at odd months. Wow, that's as we could look for a financial completed within the last 90 days prior to and we also require the form be submitted before the expiration of your renewal. So if you're up in November, you could submit it. You could submit an application in June if your license is up in November, couldn't you? Mm-hmm. Nobody would do it, but you could do it as of June. I think our weakness is we don't have any instructions or guidelines, and I don't know. I purposely did not use the word regulations. We don't. But hey, we've been out of compliance for 5 years. We can take.
Anything to add to this, because I know you were in the meetings with me during the commissioner's review of this whole issue. Was there anything you remember that we've not discussed about? Hold up a chair. You were there when the accountancy director came in and talked to us?
In the back and not saying anything today. No, there have been so many different permutations of this discussion on this issue that it's actually hard. My recollection, or my last recollection of what was decided was that the form would be guideline to give the CPA some idea of what we would be looking at when we're reviewing the balance sheet. Requirement that they use it because of the issues that you had all discussed with them signing it. For those purposes, and that's why we abolished the form for the initial licensures because, well, for one, it wasn't giving us the information that we need to sign it, so we decided for initial licensure applications, we would accept the financial statement in whatever form the CPA felt appropriate to present it, so long as it presented the information that we typically look for on the balance sheet. So for renewals, the balance sheet would serve as a guideline, not a requirement. And I wasn't aware of the spreadsheet issue of having to input that information provided on whatever balance sheet they provide into a separate document for tracking purposes at the state level. But as far as I remember, that balance sheet was to serve as a guideline, not as a formal requirement that you. But we had this discussion so many times that it's hard to keep straight exactly where we ended up on this issue. But there have always been issues, there have always been concerns, there have always been problems, and I don't think we ever arrived at a resolution that was very stable.
No, but the
because issues
form
kept coming
has
back up.
always been acceptable. It's never been handed down to me that.
Right, and I think that there have been sort of conflicting opinions as to can we use it, can we not use it, what are we doing about this, what are we doing about that. It was a discussion that was ongoing throughout my tenure, throughout her tenure. You know, it was an issue we sort of came into, and then when I left, it was.
Have there ever been any serious problems as a result of,
No, the problem as I saw it was always the acceptability of the form or the usefulness of the form or how to the degree to which providing the form complied with the law, as Mr. Herb pointed out.
Elizabeth may be asking is have we ever had a problem because of the information on the form?
No, not that beyond someone appearing to be in a negative net worth situation or, we would solicit an explanation as to the discrepancy, and usually the explanation would be sufficient. I can't remember ever.
Financial upside down, we've had complaints about that, but.
Right, but those were ones that didn't progress much beyond the initial request for a response.
That information did come in on these forms.
Yes, to a large extent.
Because the manager had to attest that it was true, and he didn't want to tell us that he had money in his trust account that he didn't have a trust account. Now, we can assume those couple of managers that you and I, Donna, we had a meeting in your office one day about one that had some issues with his financial statement.
I'd say that about, and Judy's here, which I'll ask her, but my estimate would be about 30% of those forms go back to the agency saying you left off escrow account, you didn't give us the name of your CPA/PA. Am I right, Judy? About 30%? About 30%. So we do scrutinize them and make sure that they're filled out properly and that are in trust and that their assets outweigh their liabilities. Knowing the figures on there are 100%, we would.
There's no way of knowing other than the affirmation of the person filling out this form. think what we're trying to do is comply with the statute that says a financial statement prepared by a licensed CPA, and this is not prepared by a licensed. Are we complying with the law or not, and are we making it too difficult on have a CPA? And if they don't have a CPA, I'm a little concerned about them, quite frankly.
Oh, I hate to make it overly difficult for the small agencies. The code is the code. I mean, the balance sheet has to be prepared by a licensed CPA. However, I have some level of comfort with it being the last year-end balance sheet, is to not create undue harm. You know, if my application, my renewal is in April, and I had a 12/31/12 balance sheet and financial report from my CPA, I'm
Yeah,
attesting to what's on the
then we're
paper.
in compliance with the law.
Right.
It doesn't have any independent dates, and we're still using this form.
Yeah, I'm attesting to what's on the paper, which is going to indicate hopefully a factual position of where I am at that moment. But then, as a regulatory board, I'm confident that at least each year a CPA is attesting to. Well,
I think that's reasonable middle ground.
I do
really
too.
do.
I mean, if I had a December 31 statement prepared in my application, I submit my renewal in April, I swear essentially to what I put on the form, and I include my latest balance sheet by my accountant, happens to be 12/31/2012.
What if your application's due in November?
At least you know the board knows each year a CPA is preparing and is at least advising that business owner, you're out
11
of
months
trust.
behind on financial information
But we're
we're
still better than
approving.
we were because we never had it before.
Well, the 62/2012 says all licenses and identifications cards shall expire on December 31st, which tells me that the balance sheet should be prepared on December 31st. Yeah, as of December 31st.
Typically, from a CPA firm, you're not going to have your financial statement until maybe as late as March, and if you're getting audited, it's going to be April for your prior year. Timing of all that really is confounding.
Yeah.
But this form, I have no issue with the form. But requiring the CPA's name implies something that's not real. I mean, as somebody said earlier appropriately, you could put any CPA's name. There's no correlation between who you list on this because there's no signature from the CPA. You know, I think I've opened too big.
Maybe we should consider it and see if staff has a recommendation for our next meeting and something that we could act on. But clearly, the law says the accountant has to prepare a balance sheet. That has to be submitted. It does not say whether or not last year-end, fiscal year-end balance sheet would work. The implication is it's supposed to be current.
Well, it says a current balance sheet.
It also, and current typically is defined, banks will accept a balance sheet within the last 12 months of P&L
Current.
financials as current. Typically around 10, 11 months, they get a little waffly, but so a current financial prepared by a CPA could be anything prepared within a period of time. Now, there does not appear to be any requirement that the date on this balance sheet agree with the date on the CPA's form. Now, if we actually take the CPA prepared financial, prepared within the last 11 months perhaps, and accept that and have a different date on it, then we are meeting a standard that this company is having their information reviewed by someone on the outside and another set of eyes.
That's right.
They have to go through the filter. If the law is only requiring or saying we want to know that there's an outside filter on people who are messing with trust funds, it doesn't say that filter has to be in line with the same date. So we could just require the most recent financial prepared by a CPA to be attached. It'll be confusing to some because most people that prepare these will assume that the dates have to be in line. And again, some simple instructions might clarify that. But we would meet the standard of the law having and I add the word current financial statement prepared by a CPA, and would meet the standard to be able to know that they're in compliance by having this one filled out.
Want to get calls from CPAs and lawyers saying, but your statutes say only submit a balance sheet.
You can say, submit at a minimum a balance sheet. We will accept a balance sheet and any other financial information that's normally prepared with it. So the fact that they stick on notes and P&Ls and cash flow statements and blah, blah, blah that they stick in there, all you want is the balance sheet. They've met the standard when they submit a balance sheet. That's all. They don't have to only submit a balance sheet, but they have to submit a balance sheet. I don't mean to split.
Hey, I think that this deserves some thought. I'm not a CPA. We have one on the board. Thank goodness. It has been an issue since I've been a collection agency for 30 years, this whole issue of presenting statute specifically says that it has to be prepared by a CPA.
Statute says we have to have a financial prepared by a balance sheet prepared by a CPA.
That's the middle ground that we talked about, that would be okay, and that would satisfy the statute, satisfy everybody, and satisfy Donna's office. The problem that we have is you're going to have mom and pop agency out there saying, I got to have a financial statement dated as of the same date that I'm applying for the instruction on the application form stating that the statement from the CPA does not have to be the same date that this.
I would like to request that we consider having instructions. We spent a lot of time in my early meetings trying to prepare a statement we'd put on the website about what debtors could and couldn't do. And the level that we went to on that was so good, but if we just had simple instructions that could let the person who's preparing it know what we're thinking, we'd kill a lot of phone calls. That, you have to have a balance sheet within a time period from the date you're filing it. Very simple instructions would clear up so many of your phone calls if we could attach those to them. And it's the same stuff you'd say on the phone. I know that in preparing forms, everybody looks for some level of instructions on what a line is supposed to mean in just everyday common language. I don't think we're prohibited from that, and we're not deeming them to be a regulation. They're not enforceable. They're just instructions or guidelines, maybe. But if we might prepare that and say, here's kind of what we mean by this, it really would save a lot of phone calls. I know that.
Really still unclear as to what, besides the balance sheet, you would like agencies to submit. And then I would like to know if we can do that based on your current statutes and rules. So if you would give me...
Let me see if a non-accountant, let me mirror back what I think I've heard from this board. We have the form that the agency, the responsible person, the agency manager has completed before, and on that form they're attesting to the validity of those numbers. Also, the statute requires a balance sheet prepared by a licensed accountant, CPA, relative to that. What we're saying is, you fill the form out, submit it, and include with it your last balance sheet as prepared by your CPA or your public accountant at your last year-end close is fine. Needs to be current, which by definition could be in the last 11 or 12 months. So, as an example, if I have a June 30th year-end and my accountant's come in the fall and done all her work and she's prepared a reviewed statement for me, and my application renewals in February of the next year, I'm going to fill out this form based on my February numbers as best I know them, and I'm going to attest to them. But I'm also going to include a copy, at the very least, of the balance sheet that my accountant did last fall for our June 30th year-end close. I may just, and what we would probably have done, is just included her entire report and just clipped it on the back. So as a staff, you guys know, hey, Hellman and his company, they do have a CPA who comes in each year and does year-end work, and that's good. So if they were out of trust at June 30th, he probably was notified by his accountant that, we have problems here with the trust. But you also have my essentially affidavit, if you will, that the numbers I've provided to you as of the February renewal are, to the best of my knowledge, complete and accurate numbers. They may not line up because the accounting periods were different, but you will probably get more than just a balance sheet, as the law requires, as the code requires, because the accountants typically give a whole packet, and nobody's going to want to sift through and say, well, pull out a copy of the balance sheet, because they're just going to say, make a copy of the CPA report from June 30th and send it to the state. That's what we would do in practical terms, along with this application. So you're going to get the form that you always got, signed by the manager. At this point, it still has information about my CPA. Then you're also going to get, at minimum, a balance sheet from my last year-end closed. You will probably get the whole report to keep on file and to refer to if you need, if you see anything in this report or on this sheet on my application, on the financials I've submitted that causes you point of concern or alarm as you plug them into your own spreadsheet, you may want to look back at the June 30th work my accountant did and plug those numbers in, perhaps. But you may never look at it. But at least you'll know that I had a CPA reviewing my numbers. I do have one each year. Is that a layman's explanation of what you all heard?
That's the middle ground that we've.
So which balance sheet do we look at? Does it matter?
Look at this form.
Look at this.
Your form.
You look at this form, but they also have to turn in the other. And you can refer to it if you want, but this
You can just put it in
form,
the file.
you just stick it in the file. Now you've complied with the law because it says that you're charged, you must collect a balance sheet from a licensed accountant. The law requires it. What you do with it, there is no statement about what you're going to do. It doesn't even say you're going to evaluate it.
So even though it says a current balance sheet is required, we can accept their last current, their
It is
last.
current. We just heard it's as current as it's
Within
going
a
to
year,
get
it's current.
without putting undue
If you
harm.
use industry standard, a banking industry standard, if you apply for a loan at a bank and they say, I need a personal financial, I need a company financial, the bank will accept a financial prepared within the last 12 months. They prefer 8 or 9 months. 12's getting a little edgy. They'll ask you to redo it. But they'll accept a financial prepared 9 to 11 months as a current financial that represents your status for the application. So by common definition of a current financial, one that's been prepared within some reasonable period of time of the date of your filing. The information that we're requiring or you're requiring here is for a different standard, which is to test. The crossover implication between this form and the CPA preparing this form was lost when you all met with the CPA board apparently and took off the signing requirement. There used to be a signature line that the CPA had to sign it. That's gone, and now you're just getting the name. I would suggest that this signature block for the CPA be moved away from the attestation and be put in another place as just something, please provide to us the name of your CPA and your most current financial from your CPA. Now give us this stuff and attest to it. Because there is a back-ended implication by having the CPA's requirement in the same attestation line that the manager's signing, that there's some correlation between the two. But there's not.
I think for the sake of our discussion, and we've had some good discussion, that we consider how we might adjust the form or even put some additional verbiage on the form and what would you like? What would you feel comfortable as being? Tried to reach some middle ground, and we have, but there's still some concern.
This is middle ground, an appropriate place to be. The thing that I've tested and would really love to see and know as someone who's prepared these forms over the years, if I had some instruction from the board and or from your office that just said, line 1, it says what you want, but all the phone calls you get about different lines, just write that down in common everyday language of, hey, this is what this means. We want, what was the line that had to do with
Clients.
clients? Yeah.
If you're a startup agency, you should have no clients.
If you're a startup
an
agency,
existing agency operating in another state, provide us with 6 clients.
Yeah. And they don't have to be Tennessee clients.
Are we back on the application now?
No, well, I'm talking about an example of instructions.
On this,
That a company that.
on this form, you could say, where it says data statement, this statement does not have to be the same date as your CPA statement. Date is not required to be the same as your CPA statement.
Or it could say, provide a current statement from your CPA, and current means within the last 6 months, prepared within the last 6 months by your CPA, or 9 months. So we accept as current something prepared within the last 9 months. Now, fill this form out for us with your trust information within 60 days of your applying for the form, because we want to know you're currently in trust, and you're going to sign off that you're in trust. The application should be within 60 days of filling out the application and submitting it, because we're looking for trust. We're looking for them to be in trust. Those are 2 different requirements. And that's just
Possible just to get a letter along with the balance sheet?
They won't do that, because
And that doesn't,
they
that
have.
doesn't satisfy the letter of the law either.
That would be there's a name for the kind of report that would be. Whenever a CPA says anything about a financial statement, they're making some level of attestation about what they did and what they didn't do. And so they won't even mention financial statement in a letter unless they're telling you the level of service they provided or what responsibility they accept.
Did they not do that? Just in a letter form, accompanied with the balance sheet.
But it's not a current balance sheet. I think we've reached this, and we've said it several times, and I'm going to call for an end of the discussion, that as long as a current financial statement is prepared by CPA and sent along with this form that we've prepared for them, a financial statement prepared by a CPA, a balance sheet prepared by a CPA.
A balance sheet at minimum it can include other things.
Well, that's just a balance sheet, and it says a current balance sheet. So, and a current balance sheet would be considered within the last 12 months.
Yeah, you can say note, a current. The little, the things we're talking about,
I'll keep calling you. It'll avoid a whole bunch of phone calls.
FAQs, we've got ways to put notices out there and to put it on the form and say exactly what you want, and that it's acceptable as such.
Well, we don't want it. The law requires it.
Can we change the law?
Statute.
All right.
Oh, you got to go to the governor.
Well, what I'm saying is, we're trying to relax that by saying the standard for a current financial statement is over the last 12 months, which would cover your last year-end close, which would be a normal time that you would have an accountant come in and review your practices, review your business, so that they don't have to hire an accountant to come in mid-year and prepare that statement or that letter. So we're just asking that they submit whatever they did at their last year end by discussing that the term current can be as old as 11 months.
A lot of discussion, and I'm trying to boil it down here because I've got to figure out what to do. So something like a little statement just added to the form underneath there with 3 little stars, and then something like, please attach your last balance sheet plus or something like that prepared by your CPA. It will be considered current if it's prepared within the last 12 months.
Yeah.
And that,
That's it.
That's it. Move
Where
the
you
name.
been?
Yeah, move the name of your CPA down into that little section. Don't have it under the attestation section, because don't confuse the CPA's name with what the manager's attesting to, because that's where our validity is in they are swearing and affirming, and you might want to beef up that affirmation, that they're swearing and affirming this information is true and correct as of the date, and that date should be probably within 60 days of filing the application. Additionally, provide to us a CPA-prepared financial within the last 12 months and the name of your CPA, and that could be down below. Then you've moved away all the problems CPAs have with being inferred into
That
the
form.
balance sheet above, and we comply with the law by getting a balance sheet. I think it's valid to note that it's okay to send more than the balance sheet, because if you go to a CPA and say, I just want the balance sheet, they're going to charge that poor guy something awful just to write a whole new report just for the balance sheet.
But he's likely to, he's going to have a copy of the last year-end report his accountant did. So they're literally just running a copy of it and paper clipping it to the application. They're finished. Didn't cost them another nickel.
Some people get interim compilations. We would accept those too. As long as it's CPA with a report, we'll take an interim compilation, quarterly compilation. It's fine.
all right. So is it the board's request that Ms. Hancock and I work to see if we can get that proposed draft form in between now and the next meeting, and we'll have to bring it back at the next meeting for you to look at, and if it meets with your approval, vote on it. And once we have a vote, and provided that it doesn't cause any issues at the Assistant Commissioner's office or anywhere else, then we can put it to the website.
I would like to move that Mr. Whitaker and Ms. Hancock create that draft based on the comments they've heard from us today.
Motion's been made. Is there a second? And seconded, all in favor?
Aye.
Is there any other business, new or old?
Mr. Chairman, I'm sorry, I do have one other thing to bring to the board's attention. At this juncture, it's more of an FYI. Just as you well know, the board has put out a clarification statement regarding the passive debt buyer issue, and in the last couple of years, there have been a couple of cases at the federal level that have extensively delved into, what is a passive debt buyer, what isn't, what is a collection service, who has to be licensed, and, based on the case law as it stands now, down the road, the board may either want to or be asked to reconsider the passive debt buyer issue. Federal case law doesn't necessarily have binding precedential value such that it would force the board to accept it. However, it's definitely worth considering. The most recent case is still ongoing through the appeals process at this time, and it's currently on appeal with the Sixth Circuit Court of Appeals. And after discussions with my supervisor and the general counsel for the division, we all came to the conclusion that it's best that the board not take action at this time, at least pending the results in the Sixth Circuit, because it would be messy, to say the least, if the board made some major changes based on a trial court decision only to have it overturned and reversed by an appeals court 30 days later, and then have to try and figure out, how to walk it back. So that's kind of where we are.
So are you trying to, are you saying, Chris, that you think that passive debt buyers should be licensed?
I'm not saying that that's my opinion at all. What I can say is that there's some potential disagreement on that point, at least by a couple of federal judges, and getting down in the legal thorns. I mean, we probably had 3 or 4 hours worth of meetings about this ahead of this meeting, and so it's a little far up in the air. The most interesting thing I would say about the current case is that the plaintiff who was requesting that the court ask this unlicensed, supposedly passive debt buyer, maybe collection agency, because they were not licensed, they asked for the court to rule that this entity should not be allowed to collect that debt. Now, it's unclear to me at best whether a judge could even order that as a remedy, because it's possible that the Collection Service Board should be the one to pursue remedies for unlicensed conduct violations. But this particular judge ruled that because the unlicensed entity did not have a license, that served as a complete bar to this company attempting to collect the debt at all. And since there's about $20 million at stake in the case, it's drawn some interest, shall we say. We'll see how it goes, and if it stands on appeal. If it does, there will be future meetings, and once I have those meetings, I'll have more to say. But
So what you'd like for us to do is remove that from our website that says that.
oh no, we're definitely not doing that right now. That's why the meetings were held, because at the time the meetings were held, there were discussions whether an amicus or amicus brief, depending on how you like to pronounce it, which is a friend of the court brief, should have been filed by the Tennessee Solicitor General on behalf of the board defending its passive debt buyer interpretation. The decision was made that we shouldn't do that for now. The trial court ruled what it ruled, and the appeals court will do what it's going to do. And based on that, if there's future action required, then we will reassess once the appeals court decision comes down. But what I will say is that may be something that the board wishes to consider down the road, after the case is over and after more meetings have been had and I can. Yes, sir. And that's all I have.
One other thing, NACARA, is that, when do you need to make an application, or when do we need to apply for the, and where is it?
I've,
October.
It's in October. It's in Boston. Tiffany Fowley is the new president, so they're going to hold it there in Boston. I generally assume that I've been going. If the board wants to send you again, Mr. Howard, or another member of the board, that's something you guys will need to discuss. Typically, more notice is better than less. We generally don't do the request for approval until we have a more finalized agenda. Right now, according to Tiffany, we have sort of a skeleton of it, but they're still trying to fill it out a little more before.
What I'm trying to do is, because likely we'll have to make some decision before the next board meeting.
Sure.
About asking for, I'd like to go to the meeting myself. Is anybody else on the board interested in going to the Boston? Those that don't, on the board that don't know, National Association of Collection Agency Regulators, that's what it is. And it's a country that get together and meet. Terrence used to be on the president-elect when he left, so it's Hey, Elizabeth? Chip?
Well, not in place of you. Do we just send one board member?
No, we can request what we want to send. Yeah.
Typically, it's 2 people attend.
I would go with you, probably, but not instead of you.
Okay.
Does that make sense?
Yeah,
I mean,
but
I would have an
Chris certainly
interest,
needs to
but
go. I hope Chris is going to get involved at the executive level of that.
I would
say 2. Are you saying 2, including Chris? Typically.
We will submit 2 and Chris, along with Chris.
Okay.
It's more likely that you will be approved for 1 plus me.
That's fine.
But
That's
There
fine.
has been years when all of us went.
that could be.
Years ago.
I know, years ago.
Long time ago.
And if you'll remember, Mr. Chairman, I was appointed as a director, which is essentially an at-large board member
You are.
last year. So I've kind of been in on the email exchanges and conference calls so far about the agenda and things. So when I have more information, we'll get Susan working on the requests. And if the board wants to attempt to send 2, then you probably ought to do a motion and a vote right now, just so that we have the authority to do that when the time comes.
Motion that we ask for permission to send Chris. Seconded, all in favor?
Aye.
All right. We stand adjourned.
Thank you, Mr. Chairman.
Again, if